Kelly asks, Breonna Taylor's wrongful death case just settled for $12 million. Meanwhile, the grand jury is still making a decision on whether to arrest and charge the officers involved in her killing. Will this wrongful death settlement have any bearing on that decision? You mind if I've let you go first on a lot of them. You mind if I go first a little bit too on this one?
Go on.
Thank you. So it's interesting. When you have a case with a criminal element versus and a civil element, I typically I don't want to get in the criminal law's way. So usually we try to, you don't want to jeopardize the criminal case by giving the defense lawyer the chance to say somebody's just in it for money, and so they're affecting their testing. But here it's done. That case is settled, so maybe that's smart. It's interesting that this wasn't confidential, but I think for some municipalities or cities, they want to settle this stuff and get it by them. Look what's happening in I don't want to talk politics, but look at St. Louis County with that huge great verdict, hardworking gay discrimination case, and then there's another one right now, and that was in the news. And so a lot of times they want to settle these and get beyond them and change the decision makers and do stuff. So I get that. Will this wrongful death settlement have any bearing on the decision whether to charge? Well, it may or may not. A grand jury may or may not hear that. They're going to present that evidence to the grand jury, and then it's either 12 or 24 people are going to decide whether to do that. So I'm sure those grand jurors will hear that, even if they get it on Google, because I don't know if you really sequester a grand jury. It's more of a long process, these grand jury things, because they're doing different stuff, and grand juries are usually impaneled for 3 or 4 months out of a time. They'll meet a couple of days a week, or they don't want to take those jurors the entire time. So it could affect it. It also could affect the trial. But trials like that are high profile trials, in this very, very sad case of Ms. Taylor, it's the news on those cases are all out anyway. So anyway, there's my 2 cents a little bit on that, Kim.
I've represented some public entities, and I've mediated some cases with public entities. And a lot of times they really do have confidentiality issues, because they're paying tax. Usually they're paying the settlement with taxpayer dollars, and it's public. I mean, many times there are statutes that require it to be public. In Missouri, we have a Sunshine Act that makes it public. In Illinois, for many years, they were private, but then that FOIA law, or Freedom of Information Act law, was changed to make settlement agreements like this public after so much time. So they're public, which makes it really tough, because a lot of times both the plaintiff and the defendant have something. It's good for them for it to be confidential sometimes, not always, but sometimes. But when you're dealing with a public entity, usually it is not confidential. And that is, that's a point we negotiate. That's a point of negotiation in almost every single case I have. And I understand why. You don't want other people to know your business. And, maybe what one case is worth is not what another case is worth. I'm very respectful of that. And I think in these police cases, I think a lot of times the defendant is anxious to put some money in the hands of the plaintiff or the plaintiff's family, because they're suffering. I mean, I'm sure they had to pay money to bury her. They had to pay money, what a sad, the whole thing makes me want to cry. I'll put it on law. Some of this on TV, I swear, I can't watch. It's too upsetting. So
it's very upsetting to see these videos and to see this continued. It seems like every 3 or 4 months. Those are great points. On the confidentiality, though, there's also a concern among claimants' counsel that if defendants insist on confidentiality, you're stifling public information and you're preventing that. We saw with some of these non-disclosure agreements with some of these sexual predators that in the last years have been, that's a way to, then people don't know that so and so is a predacious person, or you have a company that is violating safety rules and injuring or killing people. The public needs to know that, and then we want to know. So I fight confidentiality, I think, more than other lawyers do sometimes. You and I have had these discussions before in mediations where I'm like, what? No, I'm not doing that. I want everybody to know. And I need to put it on my website. And or on my newsletter that I do, and I joke about that. And it's not about me really, but it's also people need to know. I get questions all the time. What is this case worth? What is that worth? Well, the only way you know is by showing what other similar cases have settled for. It's one way to know, unless you want to try it in front of a jury every time and settle it. So I know every case is different, and I do appreciate that some businesses have a financial interest in keeping that stuff private. But the insurance companies know all the confidential settlements because that goes into their index and stuff. So it's only confidential from the public many times. So to the extent I just would add that on that other concern on confidentiality.
Yeah, I hear you. I think you're right. It has been used to protect some pretty awful sexual predators and some pretty awful actors. And what you hope happens is that when a company, like let's say the whole Roger Ailes case, and there had been multiple cases against him, and each one they had paid off, you'd hope that the person paying the money, somebody, the board of directors, somebody, would say, we have paid out millions of dollars because of this guy. Why is he still here? Let's do something about this. That's what frustrates me.